the words, comma, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include this we clarify would comprehend the alphanumeric number of and the serial number, if any, of the bonds which were purchased and redeemed. Full stop.
Voting number 1.
The application. This was on your application. I think you had moved this. No, the application was by the Oh yeah, we had. Therefore, Mr. Harish and Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date Daldo.
Could we have one more day, Thursday?
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
Is to be given to the Election Commission
in terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details forthwith on the communication by SBI.
My Lord, I had directed, my Lord, the senior official of the bank to remain present. My Lord, the Deputy Managing Director and Chief General Manager are present at the presence.
Okay.
If your Lordship permits. But at the outset, my Lord, on behalf of the central government, I completely disassociate myself with what Dr. Agarwala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, my Lord, on behalf of the central government. Now, my Lord, I have something to share, and I have been watching this very painfully, my Lord, outside the court. My Lord, your Lordships sit in kind of a silos. Your Lordships are, my Lord, in an ivory tower, not, my Lord, in a negative sense of the term. But what we know here, my Lord, your Lordships never come to know. The way in which your Lordship's judgment is playing out, my Lord, something your Lordships must, my Lord, be informed as highest court of the country. But what has happened? My Lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy, and we could not persuade your Lordships. Lord, your Lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your Lordship wants is not, my Lord, kind of a witch hunting. Earlier, my Lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my Lord, the witch hunting has started, my Lord, at some other level, my Lord, not at the governmental level. The application comes of the SBI before your Lordships on 11th of this month, my Lord, and your Lordships also, my Lord. That's how, my Lord, we understood, clarified the position. But most serious things, my Lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my Lord, and there is, Lord, a non-level playing field. My Lord, on this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my Lord, a barrage of social media posts, my Lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my Lord, now it's anybody's field. It's an open field. My Lord, statistics, your Lordships are aware, can be twisted in any manner the person wants. It's a matter of, my Lord, intelligence of the reader to understand. Now, my Lord, based upon the twisted and other statistics, my Lord, any kind of posts are being made. I know, my Lord, your Lordships cannot control them. The question is, would your Lordships, my Lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control. Lord, that saying Mr. Rohgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of para 221.
That's
As judges, we decide according to the Constitution.
correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm
We
not,
are-
my lord,
we are-
for a
Our
second.
court has an institutional role to play in a polity which is governed by the Constitution, the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter, this started in a very systemic.
Already order.
Just one fact.
Can I assist you?
No, Mr. Rodgi, we don't need assistance right now at the conclusion of the matter.
One fact. One fact.
I am the person who's going to.
Lord, they have no stakes.
The election commission has put out the sealed covers but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into
No,
all
but
that, Mr. That's
because-
not our remit at all.
No, I
Yes, what has happened after the judgment is not something we are concerned
not
with
after
at
the
all.
judgment. What I'm saying,
Now,
no, what I'm saying is this, that since the order of the,
very recently, I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. It's the property of the nation. And
no, I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the election commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not
the names of
addressing
the
your
donors.
lordships, he is addressing somewhere else.
The-
Kindly hear him for some time.
Correct?
So that it comes, my lord, in the newspaper tomorrow, that Mr. Prashant Bhushan
Amazing,
vehemently said this. That's
amazing.
the purpose.
Solicitor,
Pointing out
unfortunately,
something-
public interest litigation have now become publicity interest litigation.
It is
Absolutely.
publicity interest litigation.
I
It
am
is, my lord,
pointing
there
out
are some hidden agendas. There
something.
is no doubt, my lord, and I am not, my lord, apologetic in saying.
I am astonished.
And Lord, that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
Lordships in your lordship's majesty
So what
would
I was
not know,
pointing
my
out-
lord, what are the hidden agendas behind it.
just dictate a short order. I
I
think,
just
we
point
are
out that
unnecessarily expanding upon the remit.
because the major political parties have not disclosed the donor.
Just give us 2 minutes to dictate the
Therefore,
order.
therefore, what all that I'm requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order,
They have filed an
just, Mr. Ansari, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes,
Right? In our interim order, we said that the disclosure shall be made with effect from the date of the interim order.
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitution Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the
So
judgment.
the only reason why I'm saying that,
Modify that date.
no, the only reason, because your lordship asked the political parties to give donor details to the election commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore, I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems, a lot of
Oh,
your issues. will get
But for
solved.
that period of 2018 till
No, that
So,
April
we are not sitting in a
29,
review.
we have taken a conscious.
we are
While
faced with a
review is-
situation where the
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
No.
And
in the light of the disclosure which has come to light of the political parties, that's why I'm saying.
it is not a.
If the
classical
political
discussion,
parties had
conscious.
disclosed the donor details, this would not be required.
Draw the line somewhere, we had to hold the balance. We've held the balance ultimately.
As your
as it
lordship
was.
pleases, but I just.
Can I just